Good afternoon, everyone. Today, we're going to be discussing civil law versus common law and the American judicial system. So why are we discussing this? Well, the United States has a judicial system, which is based on common law. We're going to talk about the differences in the state and in the federal courts. And we're going to talk about how some students who are foreign born might be coming from civil law countries and what the foundations of that legal system are, and how it contrasts with common law, which is the legal system in the United States that is reflected on the bar. And also because we will also be discussing how the judicial system is tested on the bar exam. So why is this important? Well, first of all, it's tested on the bar exam. Now, will you get a bunch of questions on the judicial system directly? No, you'll get a few, but it's still important, however, because I've had a sizable number of students who have passed or not passed only due to a couple of points. So a multiple choice question is worth a point. If you get 3 or 4 questions on the judicial system, it's a pretty straightforward thing to know. You get those right, you put yourself over the hump. It's also foundational knowledge to understand other concepts, right? So even if they're removed from an actual direct question on the judicial system itself, knowing the judicial system and knowing common law will help you kind of put some of these rules and concepts in place. And lastly, you're all taking the bar exam because you want to be licensed attorneys in the United States. And it's necessary to know this at least at a granular level so that you can practice law. So real quick, civil law versus common law. You'll see here in our map, everything in red is civil law. Everything in blue is common law. And then we have other types of legal systems which are practiced throughout the world. But you'll see that all of Europe, Russia as well, some countries in Asia, and almost all of South and Latin America, Central America, practice civil law, have legal systems based on civil law. Now we see that Africa is a bit more diverse in their legal systems throughout the countries in Africa. Some do follow common law. And then you'll see over here, Australia, New Zealand, as well as North America and England follow common law. And we'll get into why that is. And so it's important because a sizable portion of foreign applicants are coming from these countries that practice civil law or other types of law, a legal system that are not at a foundational level anywhere near what the US legal system is. So a little bit of historical background on civil law so we can contrast a little bit so you can start to look for the differences in the two systems. So civil law, or Roman Code as is known, it's known as the Roman Code because it was established by Emperor Justinian. Essentially what the civil law code, or Roman Code, does is it codifies most of the laws, if not all of them, in a society. Essentially that means that it writes them all down, it standardizes them, and there's a lot of legislation that goes into this. So whether it's a legislative body in ancient Rome or in a modern day European country, the legislature sets out all of the laws of the country or all of the laws that are applicable to a certain area of law. And essentially what happens is the judicial system, the courts, apply those concepts from the judicial code. There's some interpretation, but there's not a wide range of interpretation. And there's almost never a making of law through the judicial process. The making of law is almost exclusively left to the codifying of the laws, which is done via the legislature. So there's not a lot of wiggle room in the judicial system. Now, when we get into common law, it's just the opposite. So common law system as it's practiced today in all the countries that we saw marked in blue came from King Henry II of England, who established common law. Now, why did he establish common law? Well, he wanted to essentially consolidate power throughout England. And instead of just ripping up all the laws that they had and writing a code like Emperor Justinian did, he took the already existing laws and traditions, which had morphed into laws in England, And he essentially sent a bunch of judges out throughout England to interpret these laws via controversies. And we'll see how that actually is still kind of what happens in American society, in American legal system today. But essentially what they did is he sent out the judges, and the judges, with the help of locals, would decide controversy. So these were kind of the original juries, if you will, right? It's the judge and the jury deciding how to interpret the laws of England at the time. And essentially what happened, once these judges decided controversies and interpreted the principles of law and tradition that existed in England, the decisions became binding, and that's called precedent. That's something that you're going to see a lot of as you study for the bar exam. Presidential decisions are decisions made by the Supreme Court, which are essentially law. It's law made by the judges. Why? Because they're interpreting a body of legislature, which is usually a constitution or laws that were written by the legislature, and they interpret them. And sometimes, if the legal principle is very broad, they make more specific laws that they determine is how the legal principle should be interpreted. So how does this contrast what we had just said in civil law? There's a lot of leeway for judges, right? And as you have hundreds of years of judicial history, these case decisions, which are presidential, become part of the legal system. They become laws, right? And this is tested throughout the bar exam. So the U.S. judicial system, as we said, it's based on common law, as you saw on the map. It comes from the English method. And what does it do? It mostly interprets the U.S. Constitution. At its very base level, that's what every part of the judicial system is doing. It's interpreting the Constitution. Even if it's interpreting another law that was written by a legislature, that law has to be written from the principles founded in the Constitution. No law can be written in the United States if it goes against the U.S. Constitution. Now, who determines if it goes against the U.S. Constitution or if it correctly applies the U.S. Constitution? Judges do. They interpret the law, and sometimes they even make new laws. So Article 3, Section 1 of the U.S. Constitution establishes the court systems, the federal judiciary, which we're going to get into how it's set up. It's a hierarchy of structures, right? You have appellate courts, you have trial level courts. Now, parallel to this, state courts, because states have their own constitutions, yes, they are under the federal constitution, but they also have a lot of autonomy to establish their own respective courts, and that's what they do. So a lot of times the judicial systems are in the federal level versus the state level are parallel to each other. So a quick graphic on that, what I was saying before. So over here we have the state court system, and you have essentially 3 levels of court systems throughout the United States. Some states have an additional intermediary, appellate division, depending on what kind of case it is. But don't worry about that, because for the uniform bar exam, what you're going to be tested on is more likely than not, and when I say that, I mean almost always going to be the federal court system. But at the state level, it's important to know that you have state trial level courts. You have state courts of appeal, so they hear appeals from decisions that were made by the trial court. And then you have the state Supreme Court, which is essentially the ultimate decider of state cases, right? On the federal court side, you have essentially the same thing, but they have slightly different names, and it's important that you familiarize yourself with these names because that's how they will be referred to on the test. You have U.S. district courts. District courts are the same thing as the state trial level court, but on the federal side. So they're called U.S. district courts. Then above those, you have the U.S. courts of appeals. They're also known and regularly referred to as circuit courts. And this goes back to earlier when King Henry II had sent the judges out to go throughout England and decide cases. Well, the U.S. initially intended judges to do the same thing. And the idea was that they would go through a circuit throughout the United States making these decisions. And so the name stuck. That's not what happens now. There's separate courts already set up there. There's not judges traveling around, but that's what they had originally thought they would do. So that's the name, hence the name circuit court. Okay, but it's all it is. It's a court of appeals. And then at the very top, you have the Supreme Court of the United States, which is the ultimate decider of the US Constitution. And let's see. Now, there's sometimes, instead of going just parallel like this, okay, where the state court controversies make all the way up to the state Supreme Court, and then that's where they end, and federal cases work their way up to federal judiciary, and that's where they end. You have an exception like this, where there is a constitutional or federal controversy, okay, which is happening at the state level, right? Which there's different reasons why state courts might hear argument or might hear cases that touch on some federal or constitutional controversy, sometimes because it also has a state issue to be administered, etc. But the point is that sometimes the state courts hear those types of cases. So a case would essentially work its way up the state trial court to the state court of appeals, then to the state Supreme Court. But, which is typically the last level of review for a state case, right? However, if the case that was working its way up to state courts carries a constitutional or federal controversy, then the United States Supreme Court, which is, we saw here before, it's on the federal court system, right, can actually hear the case, even if it worked its way up the state court system. However, what will happen is it'll skip the US Court of Appeals and the US District Courts. It'll just go all the way up the state court system, and if there's a constitutional or federal controversy, then the United States Supreme Court will hear the case. So this is an exception, one exception to the general concept that the court systems at the state and federal level are usually parallel and distinct from each other. Another way in which a case that starts in a state court can wind up in the federal judiciary is by removal. You guys are going to run into this concept when you do civil procedure, and it'll go into detail, but here I'm just giving you the general gist and idea of how the judicial system would work. Essentially, if a plaintiff brings a case in a state court, but the case could have, for some reason or another, been brought in a federal court as well, the defendant has the power to remove the case from the state court to the US District Court. And once it's removed from the state trial court to the US District Court, then it'll work its way up the federal judiciary, right? So going back here a couple of slots, parallel systems, but there's the way down here via removal in which it makes its way over to the federal judiciary, okay? And the United States Supreme Court could wind up hearing the case. So this is another major exception to the general concept of the court systems at the state and federal level being parallel from each other. And it's important to know because it is tested. So now let me just give you a general visual on what the federal US district courts look like. If you notice the difference in the shading in each state, okay, this is obviously a map of the United States, you'll see that different states have different levels of shading. Some states have just one color, one shading. And that's because there's only one US district court for the whole state. You usually see these in the states that have lesser populations, right? So if, for example, I don't know which one of the Dakotas this is, oh, these two, they have like 300,000 people in the whole state. So you don't need to have more than one district court. Now, if you work your way over here to New York, a state of, I think, approximately 24 million people, 8 million people alone just in New York City, then you have different district courts. You have down here, this little stretch, that's Long Island and Queens. That's called the Eastern District, Brooklyn. Then you have Manhattan, the Bronx, and a little bit upstate. That's called the Southern District. Then over here, you have the Western District, which I believe is where Buffalo is located. And then you have the Northern District, which is largely a rural part of New York State. So these come in different quantities, if you will, due mostly to the populations of the state. But the district courts of a certain state are federal, but they sit in individual states, but they decide federal controversies in each state, and they can vary in size. How many federal courts or district courts sit in each state is not tested on the bar exam, but it's important to know, because if you get the legalese of the Southern District Court or something in an MPT or in an essay, you need to understand that they're still referring to a federal court, which just so happens to sit in a particular area of a state. That's all it means. Okay, now you have the federal U.S. Courts of Appeals, or the circuit courts. Now, notice this, the shading in different colors are different circuits, right? Now, these are some of the separate circuits that we have. And in these circuits, you'll notice that they cover different states. Now, they'll always cover a whole state. They won't cover half a state. But for example, the Seventh Circuit only covers 3 states. Then the Sixth Circuit covers 4. Then you have the Ninth Circuit, which covers a bunch of states over here, right? The Fifth Circuit only covers 3, right? This is just how it was decided as far as where a circuit court will have jurisdiction. Typically, it's broken up based on population, and geographic size, I think, is also considered, but I think generally population, right? Now, will you get asked on the bar exam, what states does the Ninth Circuit cover? No, you will not get asked that. But it'll be important to understand that a court of appeals, a circuit court, will have appellate jurisdiction over a case, okay, that comes from one of these states. If it sits in that circuit, if the state is in that circuit, then the circuit court will have appellate jurisdiction. Now, the Supreme Court of the United States covers the whole country, right? So any case that happens during the within the jurisdiction of the United States is subject to review by the Supreme Court of the United States. Now, unlike, or rather like circuit courts, the Supreme Court has appellate jurisdiction, but which is, as we showed in the graph, it works its way up either from a state court, and then it has a federal issue, so the Supreme Court can hear it, or it just works its way up the federal judiciary the whole time, right? Or it gets removed to federal court and then works its way up to the Supreme Court. The Supreme Court of the United States has appellate jurisdiction. However, just like the district courts have trial level jurisdiction, which is original jurisdiction to hear the cases, right? To try the case on the facts. The Supreme Court will also have original jurisdiction over some types of cases, right? When we think of the Supreme Court of the United States, we don't usually think of somebody having a trial there, but they do have original jurisdiction to carry out trials in certain concepts. The major ones are admiralty law, meaning crimes that happen on the high seas. And the idea behind that is because it doesn't really happen within the jurisdiction of any of the district courts, right? It happens in the ocean. So where else are you going to have the trial? In the Supreme Court. They also have original jurisdiction over cases against ambassadors, diplomats, etc., ministers of other countries, right? And they also have original jurisdiction, most importantly and probably most commonly tested, when it's a state versus another state suing each other. Why? Well, you can imagine if, for example, Texas is suing New York, well, then where are you going to hear the case if not in the Supreme Court, such that it would be, it's a word I'm looking for, fair and equitable to both the litigating states, right? And so that's why the Supreme Court will have that limited original jurisdiction to hear cases outright first off. And then it has the appellate jurisdiction that we discussed. Now, how is the judicial system tested on the bar exam? This is really the most important question, right? So it's really mostly tested in constitutional law, which is MBE and MEE, and in civil procedure, which is also MBE and MEE. So that means you can get a multiple choice question, and you can also get an essay question. More likely than not, you'll get a multiple choice question. Now, when it's constitutional law, they'll test judicial review. So they'll test things like what we talked about here, where they'll give you a set of facts where somebody started a case in state court and they worked it all the way up, and then the Supreme Court ruled against the person, either the plaintiff or the defendant, and then they want to kick it up to the Supreme Court. And the question asks you, can the U.S. Supreme Court hear the case? And you need to identify if it created a federal or constitutional controversy, or if it fell within an exception to the general rule that the judicial system at the state and federal level are kind of parallel and separate from each other. So that's one way that it's tested. Another way is appealability. So they'll ask you outright, can this case be appealed, right, to the Supreme Court? And you'll need to know the specific rules around that. And also, when you get down to civil procedure, they'll also ask you if the appeal is timely, etc. So this goes back to the concepts that are not necessarily directly attached to how the judicial system is formed, but that if you don't understand it at a foundational level, you're likely to get the question wrong. It'll also ask you around, not so many questions, but you'll get a couple here and there on original versus appellate jurisdiction. So that's where you'll need to understand that generally the district courts are the ones that have the original jurisdiction to hear the case, to try the case. The circuit courts have only appellate jurisdiction to hear cases, and the Supreme Court has mostly appellate jurisdiction, but original jurisdiction to hear some cases as well. Lastly, also a detached concept, but it's important to understand, is judicial standing generally, right? So you'll get a lot of questions actually in constitutional law around judicial standing. Is the case carry an actual injury in fact? Is there a causation? Can the court give redressability? Is the case moot, meaning it's essentially not ripe for judicial review because the controversy is already expired? All of these are limitations to get a case into court, which are tested in constitutional law. If you don't understand how the court system works generally, you're going to have trouble understanding why there's limitations to hear the cases, right? And also, the doctrines of judicial standing, some are written into the Constitution, okay? And then some are essentially rules that came about because the Supreme Court made decisions, which goes back to the concepts of common law, which we talked about in the very beginning, where there were general principles in the Constitution around judicial standing. And then the Supreme Court heard the cases regarding judicial standing and decided to add some more rules as they interpreted the principles in the Supreme Court. So notice how the common law comes into play into the questions as well, right? A little bit more removed. They're not outright asking you, hey, why did this happen? Oh, and you say common law, but you need to understand that those concepts came about and are rules tested on the bar exam because of the common law legal structure that we have in the United States and the judicial system that we have as well. Then for civil procedure, you'll get asked questions on jurisdiction generally. So one of the heavy tested topics is around, can the U.S. District Court for the Southern District of, they'll say state A or state B, can it hear the case? And you need to understand what state the court is sitting in. You need to understand what case or what state the litigants are in to see if the court has jurisdiction over the litigants, to see if the court can hear the type of case. And those are all very heavily tested topics on the civil procedure portion of the bar exam. And so again, having a good foundational knowledge will give you the tools to understand those more convoluted rules. And then removal, as we discussed here, right? There's more rules to removal when a case can be removed. We just gave you the general principles, but when you hear removal, you need to understand how it's an exception to the general rule that the legal systems in the state and federal level are generally parallel to each other. So to recap, the United States follows the common law method from King Henry, and there's also reliance on precedents and judge-made law. Essentially, the majority, if not, the majority of what you're going to study in constitutional law is based on precedents, decisions made by the Supreme Court, which then became law that you need to know for the bar exam. You need to also remember that the judicial systems are mostly parallel at the state and federal level, but that there are some exceptions, and those exceptions will show up as rules that are tested on the bar exam. And lastly, you need to know that it's going to be mostly tested in constitutional law and civil procedure. It'll make a guest appearance here and there in other subjects, but that's really where you're going to run into this. And so make sure that you have a good foundational knowledge of our common law system and of the parallel structures of the state and federal level so that you can understand how the rules will be tested, etc. All right, so best of luck and keep studying, and you all will do great.